I tried.
This is an interview with Simon Lorne for the SEC Historical Society's Virtual Museum and Archive on the History of Financial Regulation. Today is April 2nd, 2025, and I'm Kenneth Durr. Simon, great to talk to you today.
Great to be here.
Uh, we've got a lot to cover, but I want to jump in and get a little bit of your background before we start into the SEC stuff. And I was interested in the fact that early on you were looking at both business and law. Tell me about how that came about and how you reconciled the two.
Uh, well, it came about in a way backwards. When I was in college, I couldn't figure out what I wanted to do, like a lot of college students. And in my senior year, I was an economics major, and I applied to law schools, business schools, and schools of economics. And I got various acceptances. And I just couldn't decide what I wanted to do. And I thought law had more optionality in it. And I could, if I went to law school, I could always do business. But if I went to business school, I couldn't do law, sort of thing. So I chose law school. Nobody in my family had been a lawyer. And I didn't really have much idea. It turned out when I was in law school, I fell in love with the law. And uh, the last 20 years, I've been inside an organization, but I still read cases, even though I don't very much use the cases. Actually, in the last year or two, that turned out to be useful. But I read cases because I enjoy the law and I enjoy reading them. But I gravitated toward the business side of law, and have spent my career as a lawyer for businesses or within businesses or regulating businesses. Uh, and combine both interests.
It looks like you were so interested in the law itself that you became a professor. Is that right?
Uh, yeah, yes. And part of that, I did fairly well in law school, and it intrigued me. And it turned out I enjoyed the process of thinking about law, and you do that a lot more in a law school environment. So that for all of my, pretty much all of my career, I was teaching as an adjunct at one point in 1978, I think it was. I took a year off and spent the year teaching at the University of Pennsylvania Law School. And now I'm an adjunct at the University of Texas Law School, and turns out teaching is one of those things that it will absorb as much time as you have to give it. So that my wife tells me I work as hard now as I did when I was full time in the employment of an organization. I just don't get paid as much.
So you went to Munger Tolls,
Yes.
early 70s. Um, I know that, a lot of what you did you can't talk about, but tell me about the firm and tell me about the types of cases that you handled.
Friend of mine in Dallas distinguishes between stand-up lawyers and sit-down lawyers. And in that context, I was a sit-down lawyer. I had little or no involvement in litigated matters and was entirely, at that time at least, and maybe still, a lot of firms had rotation programs, and you'd spend 6 months in a labor department and 6 months in litigation. So Munger Tolls didn't have such a program, and that was one of the things that appealed to me about it because I knew where I wanted to be. And at the time, Munger Tolls was a much smaller firm, still a fairly small firm, but I think I was the 15th or 16th lawyer in the door. And because it was smaller, it had uh, much more opportunity for various kinds of work to be sent down to the youngest lawyer. There weren't that many lawyers around, and there were. uh, a few lawyers at the top of the firm who had established reputations. And so there was a fair amount of work coming in, and gee whiz, with when I started practicing within a month or two, I was effectively the only lawyer doing work for two or three public companies, for example, relatively small public companies, but those were opportunities, and it was a little bit more than 2 years. I was a partner in the firm, and we kept going. It was a wonderful experience to be part of a good group of lawyers and a growing firm. But as I said, it's still a relatively small firm with only a couple of hundred lawyers. Uh, but
Were
it
you
was great.
doing securities practice basically, or were you doing M&A, things like that?
Both. I was always much more of a generalist. After I did the teaching stint, which was when I was 7 years into practice, I wrote a treatise on mergers and acquisitions that has grown in volumes. I haven't had much to do with it, but my name is still on it. Uh,
Nice.
but the publishers keep growing it with other people. But I did mergers and acquisitions. I did public offerings. Uh, Again, it was a smaller firm. You could do that, and I enjoyed doing that. Uh, the impression I have is it's much harder to do that in 2025 than it was in 1971.
Yeah. Um, Talk about some of your initial interaction with the SEC. You would have been on the other side of the table, but tell me about your experiences there.
Uh, they were, I think, fairly typical kinds of experiences. Again, not enforcement matters, not litigation matters, but a lot of interaction with the Division of Corporation Finance. I represented both companies and underwriters in a number of public offerings. I had one experience at that time. There was some uh, dispute as to whether a spin-off of a portfolio company required registration. And there was an argument that there was no sale involved because a sale involves a transfer for value under the definition. And if you're just distributing the stock to your shareholders, you're not receiving any value. And the SEC took the position in a few enforcement cases and was successful in taking the position at first that that required registration. And I had a client who was spinning off a subsidiary. In fact, I'm still the vice chairman of the board of that subsidiary all these years later. Was spinning off a subsidiary to its shareholders, and I got into discussions with the SEC. I think it started with a no action letter request that was, of course, at the time turned down. So I both filed the registration statement and registered the offering and published a law review article that I think was in the Texas Law Review about why registration shouldn't legally be required under those circumstances. And I may have said something in the prospectus about denying that registration was required, although I'm not sure that, I'll rephrase that, although I think that doesn't really do any good if you end up in litigation, but we never ended up in litigation regarding the transaction. But there were a lot of interactions, and I was representing also a couple of broker dealers, uh, a regional firm in Los Angeles and a regional firm in San Diego that had a number of interactions with market regulation and those kinds of questions. So there was a fairly heavy securities element to my practice from the beginning.
Okay. I didn't write down the date, but at some point you testified, I think, before Congress about uh, small businesses and securities law. So you must have had a reputation that was growing up. Can you tell me about, do you remember that incident when you were,
Yeah, barely. I remember that it occurred, and I don't remember very much about it. And I mean, Congress is a funny animal, as we know. And there was a congresswoman from, I think, Long Beach, California, and she knew a couple of people in the firm, and I think it evolved from that. Uh, and so I was invited to come back and testify, and of course, as a young lawyer, that was sort of an exciting thing to do.
okay, so that was pretty early on then, I guess.
Yeah, yeah.
Okay. Any other highlights from your time in practice before you got into the commission?
Uh, well, a number of things. I had by the time I came into the commission, I had two fairly active clients. One was Berkshire Hathaway, Warren Buffett's firm, and Charlie Munger was Warren's vice chairman until Charlie died a little bit over a year ago. And I fell into a group by for purely fortuitous circumstances. There were a small group of people in the industry, seven or eight of us, who met for breakfast every morning in the old Stock Exchange Club in Los Angeles. Whoever was in town would meet for breakfast between 7 and 7:30, read the paper, and talk about what was there. And Charlie Munger was part of that group. And Charlie was an enormously influential person in business history in the United States, but in the firm as well. And for a period of close to 20 years, uh, I had breakfast with Charlie most mornings. And at the end of the breakfast, we rolled the dice to see who would pay for the breakfast on the theory that if you're there every day for 20 years, you're going to pay for as many breakfasts as you eat. But it was influential and importantly formative for me. The other client was the old Price company started by Saul Price, which is today's Costco. And in fact, the Costco started an officer from the Price Club, the Price Company, Jim Sinegal, wanted to start a company in the Northwest. And as I said, Saul Price was the chairman and CEO of the Price Company. And Jim said to Saul, I'd like to start a company in the Northwest of my own, kind of like this. And he went with Saul's blessing. Indeed, Jim was one of the speakers at Saul's memorial service several years later. Uh, and in 1992, I think it was, roughly 1992, uh, the Price Company and Costco were just about the same size, just about the same facilities. You couldn't tell the difference between them if you went into the what they call warehouses. And they had as close to a merger of equals as you can possibly have. And that was the last transaction I was engaged in, the merger of Costco and the Price Company, both fairly substantial public companies, before I showed up on the commission's doorstep.
You said those breakfasts with Charlie Munger were formative. How so?
Just listening, we would read the typically the Wall Street Journal and during breakfast, and there was a Wall Street Journal at every place, and we'd all be reading the paper, and somebody would remark on this company doing such and such a thing. Sometimes it was Charlie, sometimes it was me, sometimes it was somebody else at the table. and Charlie was not at all reticent to share his views of anything, and Charlie would talk about why they were doing it. Berkshire Hathaway at the time was a smaller company. It had a stock which at the time was relatively highly priced. As I recall, it was about $300. Uh, Now it's border on $750,000 a share for the A shares. Uh, but it was the same company you read about today. It was just a lot smaller, and Charlie had views about everything going on and shared those views, and I learned a lot from Charlie.
Okay. So at one point, I guess, was it 93, you were approached by Chairman Levitt? Is that how that worked out to become general counsel?
Well, that was a typical Washington phone call. Uh, I got a phone call from an intermediary that said if and this was the first year of the Clinton administration, and Arthur Levitt had been named as chairman, as you said, and confirmed. And I got a call that said if Chairman Levitt wanted to talk to you about being general counsel of the commission, would you be willing to talk about it? And it was like being in college and asking a friend to call a girl and ask her if she would go on a date with me if I asked her. Uh, uh, and I hadn't known Arthur at all, but I said, I was a securities lawyer. The chairman of the SEC wants to talk to me. I'm going to talk to the chairman of the SEC. So I flew back to New York. At the time, it was shortly after the Solomon Brothers scandal, when Solomon had some misdeeds in the Treasury auction market, and uh, I Warren Buffett at that time came in as chairman of Solomon and installed Bob Denham, my partner, who unfortunately passed away a couple of weeks ago, who was a wonderful lawyer. And Warren installed Bob as general counsel, and then when the immediate emergency was over, uh, Warren left, and Bob Denham moved up uh, to chairman, and I came in as acting general counsel of Solomon, so I was in New York quite a bit. And I don't remember who called me, that I would be delighted to talk to the chairman of the SEC, and I had a meeting with Arthur, and uh, then probably about a month or two later, actually, there's a funny story about this too. Month or two later, uh, Arthur asked me if I'd take the position as general counsel, and I was thrilled to do so. As it turned out, it was about that time the Los Angeles County Bar Association, the Business and Corporations Law section, had an annual program with the Securities and Exchange Commission. The typical securities law conference in Los Angeles. It's still uh, going on, being led by my friend John Hardigan. Uh, but I had gotten to know Stan Sporkin, and Stan, of course, was the longtime head of the Division of Enforcement before he was general counsel of the CIA and then a federal judge. And the annual program, we had an ethics session. Ethics sessions are always put at the end of programs so people will stick around to get ethics credit. Uh, and that panel, I was on that panel along with Stan Sporkin, and that program turned out to be on the day I was announced as general counsel. And so Stan saw me and said, "Well, we're on the panel together, and you're going to be general counsel." And Uh, that was an amusing coincidence.
And people were extra interested in what you had to say, I imagine.
Right, right, right.
In your discussions with Arthur Levitt early on, did you get a sense of his program generally, or what his expectations were of the General Counsel's office?
Uh, yes, I did, but I'm not sure. I'm not sure where they came from. Arthur was not a lawyer. Arthur had been involved in the securities industry, starting with the small brokerage firm CBWL, Kogan, Berlin, Weil, and Levitt. And then he'd been chairman of the American Stock Exchange. But he didn't really know the insides of the SEC, but he told me he thought of the general counsel's office as effectively the chief operating officer of the commission. Uh, and some refer to the general counsel as first among equals. Mostly that's general counsels, not former directors of the other divisions. Uh, but he asked me if I would come back and do it, and I was delighted to show up.
That's interesting. I'd never heard of the COO analogy. Did that work out? Did in your experience, was that a good characterization?
I don't know, it's a much more collegial uh, relationship with the division directors, and I we'll probably get into it later. I certainly had moments of disagreement with Bill McLucas, who was director of the Division of Enforcement, and Linda Quinn, who was director of Corporation Finance. Uh, uh, I was quite close to Barry Barbash in investment management and Brandon Becker in, uh, I guess, was market regulation then and trading in markets before and after. It was a much more collegial relationship, and we'd have weekly meetings and discuss things and come to conclusions, and uh, if there was general agreement among the group, Arthur would usually go along with that, and if there was a decision that had to be made, if there was disagreement, as sometimes occurred, Arthur made the decision. So I don't think it was really comparable to a chief operating officer. I think it was a much more collegial group.
Okay. You mentioned ethics a little bit ago, and I was interested to see that in 93 when you came in, you were uh, in a along with your other responsibilities, you were the agency ethics official.
Yes,
You
but
were
we had a person who was focused entirely on that, and I, I was designated as the agency ethics official, but all of the questions went through her office, and when she had an issue, she came to me and we talked about it and came to a rational conclusion. But I've always had a strong interest in ethics. I've taught the ethics course. I had a wonderful experience teaching an ethics course to the joint New York University Law School and the Stern School of Business at NYU. One of the interesting things, sorry for the digression, but one of the interesting things of that was that in the class, which was about half business school students and half law school students, and of course, the lawyers have the model rules of professional conduct and the whole history of ethical concern going back to the early 1900s. Business students don't have any such code, but when you talk to the students, you generally couldn't tell who was a business school student and who was a law school student, which was, I thought, quite encouraging. Every so often, a law school student would talk about a case or something, and you knew they were a law school student, but other than that, you couldn't really tell. Anyway, I was chief ethics officer. And at one point, our ethics officer left to uh, be running the program at the White House, and we had to appoint a new officer, which fell to me, at least in the interviewing and initial decision stage. And I remember well that I used to say to everybody I interviewed, there are two critically important things in this office. One is to be able to say no to the chairman of the SEC, who is almost by definition a powerful individual with a lot of experience and quite self-confident, and certainly Arthur Levitt fit that bill. The most important thing is to be able to tell Arthur Levitt he can't do something he suggested. And the second most important thing is to be able to say yes. And with those two, it's important to know when the right answer is no and when the right answer is yes, obviously, but you've got to be willing to do that. I think over the last several years, too often no has been the right answer because it's the easier answer. You're never going to get in trouble in the newspapers or the chat rooms saying no. You might get in trouble with the chairman if you say no when you shouldn't, but you're not going to get in trouble in the public perception.
Well, great. Let's dive into some of the meat of the things I wanted to talk about. We've got some categories here, and this was a period when internationalization was big. There was a lot of concern about sort of making investors overseas more comfortable in American markets, more able to do business here. Um, and you were involved in a few of these, I believe. Um, Talk about the SEC's interest in international matters at this point, and your involvement with some of the MOUs, things like that, that were put in place.
Uh, yeah, it was interesting. Uh, it was less a focus of the chairman's at the time. He was well aware of it and paying attention to it, but less focused. I came to it with a little bit more of an instinctive appreciation. I was born in England. I grew up in an English family and moved to America when I was young. But I'd always been sensitive to the international concerns, and it was apparent then. It's become more apparent ever since that the international realm was one the SEC should pay attention to and had a natural leadership position simply because there weren't generally any equivalent organizations for a long time to the SEC in the United States. And we had, for example, an annual program where we brought regulators in from 50 or 60 countries to talk about how we viewed securities regulation and to give them insights. One of the questions I always had and used to talk about with them was whether the United States experience, which didn't start in 1933, it started a lot earlier than that, and we went through the period with the so-called robber barons, and with a lot of hard practices, shall we say. And there was a question in my mind whether it was necessary to go through that, uh, or whether a relatively new country, for example, could go directly into meaningful securities regulation. And I still don't know the answer to that, but IOSCO, the International Organization of Securities Commissioners, was fairly young then and uh, has become much more meaningful in the more recent years. and it was growing. It was a field I was interested in. Michael Mann was the head of that program internally at the SEC. Michael's a first-rate lawyer, and spent a lot of time developing it, and I gave him a lot of credit for the way in which it has evolved. And there's you don't want the United States to be in the position. Well, you we shouldn't want the United States in the position of the font of all securities law wisdom telling all other countries what they should do. And even more, they don't want to be in the position of being told what they should do. And I think the SEC's done a pretty good job of maintaining that balance and not being or appearing too arrogant in the discussions. I think IOSCO has done a lot of good. It's it's difficult, I mean, because the SEC is a part of the United States government. There isn't a world government, and IOSCO can only make recommendations to the different countries. But it's been a very good sounding board for different countries. Sometimes in my view, one country will go off a little bit off track. Sometimes in my view, the SEC goes a little bit off track too.
Yeah.
Reasonable minds can differ about a lot of these things.
Um, so it's one thing to sort of prescribe for international securities regulators. It's another thing to prescribe for what the SEC is going to do. And there were efforts to simplify registration, for example. And you would have conceivably, I think you would have had to sort of scrutinize these, look at them and counsel. Did that
That that
happen?
that's been a pretty constant pressure in the United States. You see some of it in I guess Paul Atkins is now the chairman designate, or I'm not sure if that's the right appellation. He's been nominated and had his Senate hearing, but he hasn't been confirmed yet. But in some of the questioning from the Senate, you see continued concern with simplifying the registration process, and you see industry responses to it. The whole experience with special purpose acquisition corporations, SPACs, was a drive to let people become public more easily. Uh, I think that movement had a lot of problems, and it's declined significantly in the last couple of years. But it's been a pretty constant pressure. Uh, when I was general counsel, I think the pressure was a little bit more toward plain English in prospectuses, and that's a tough nut to crack because sometimes plain English is imprecise English, and for documents that are going to potentially end up in litigation, we're all trained as lawyers to be as precise as we can, and so we get. I was looking at something yesterday that had one sentence that went on for 18 lines. And it's hard to diagram a sentence like that and figure out exactly what it's saying, but and even harder for investors to understand. But Arthur cared about trying to drive toward plain English as a means of simplifying things, and you still see efforts in that regard, although I'm not sure they've been very successful.
Yeah, notable that he wasn't a lawyer, so he
Right.
could look at it that way. So did you find yourself pushing back on that and saying, well, we would like to do that, but it's not going to work in this case?
Um, Not very much, frankly. I drafted, participated in drafting releases that said we should use more plain English. Um, but I was always a little skeptical as to how successful they were going to be.
Yeah.
And at one point we hired we, the SEC, hired an English professor to try to provide more simplified examples, but that never really got very far either.
Well, let's turn to something that I know you were greatly involved in, which is the issue of gatekeepers, um, lawyers and accountants, um, and how regulation went with them. Talk a little bit about how things had been prior to the early 1990s as far as the SEC's ability and the court's approval of the SEC's efforts to rein in uh, lawyers and
Always,
accountants.
always a sensitive question. SEC is largely a lawyer-driven organization, and so the I'll call it the regulation of lawyers has been a little bit more sensitive than the regulation of accountants, I think. Uh, uh, Maybe that's changed more recently with the Public Company Accounting Oversight Board. I don't really think so, though. But the right role for the SEC to take uh, has always been both important and difficult. I think the SEC has always realized the importance of so-called gatekeepers, professionals, lawyers, accountants, sometimes petroleum engineers, uh, prospectus experts, perhaps is a term, although lawyers try to think they're not experts. Um, but uh, the system really depends on the intermediaries. Businessmen are, in my experience, generally, and when I say generally here, I mean 90%, trying to do the right thing, but they're trying to run a business and to raise money, etc. And like the ethics officer at the SEC, the lawyer sometimes needs to rein in the animal instincts of the CEO and be what the term implies, a gatekeeper, somebody who watches the gate and says, no, you can't go through that. You can't do what you want to do that way, and maybe there's another way you can get close to it, but it's the lawyer who brings that expertise, and then the question becomes when should and when should not the SEC discipline lawyers who fail in that effort? And it's been a constant question. Ed Green, one of my predecessors as general counsel, uh, had written a fairly lengthy article on SEC uh, actions against lawyers, and I followed up that with a couple of speeches and articles on the same question. Wrote one article in the Business Lawyer with Hardy Colcutt that got some attention. Uh, Actually, the fact that it was Ed Green followed by Cy Lorne on it had some people calling it the bonanza uh, argument, because Bonanza was a popular TV show, the star of which was Lorne Green.
Oh,
Uh,
okay, I was wondering.
so
Gotcha.
some people called it the Bonanza movement. Uh, but it's something that's always concerned me, and maybe we'll get into it a little bit more later on. But it's always concerned me, and you don't want the SEC interfering with the lawyer's proper, zealous representation of a client, but you do rely on the lawyer to keep the client honest, and those two are in conflict uh, to some degree, and it requires judgment And I've long thought the SEC shouldn't criticize or discipline a lawyer for honest mistakes of judgment, but should uh, discipline the lawyer for uh, gross negligence in the representation of a client, for willful participation with a client. And we're not talking about the cases where the lawyer is guilty of insider trading, like we had in the O'Hagan case or something. Uh, Clearly, if the lawyer is just breaking the law, the lawyer ought to go to jail. Uh, but for errors of judgment, for thinking a close question, it comes down this way rather than that way. I think you should allow the lawyer a fair amount of leeway. Uh, but it's hard to figure out exactly where that line is, and it is important to the process that lawyers take the gatekeeper role seriously and recognize that there are times you have to tell the client they can't do that. Uh, I
Let's talk
remember,
about some cases in which those concepts were worked out. I think in your article you wrote a bit about the central bank case.
yes, I did. Central bank was key. This little bit comes back to Stan Sporkin. Central bank was the decision the Supreme Court came down with, in which involving, it was not an SEC case, it was private securities litigation. And the claim had been that the defendants were aiding and abetting the fraud of the principal participant. And the Supreme Court decided there was no, at least private right of action for aiding and abetting. And Stan Sporkin, all his life, a part of him was the director of enforcement. But when I was general counsel, he was a federal district judge. And I will not forget, I got a phone call the afternoon the case came down. I got a phone call from Stan. And the first thing he said was, "Si, what are we going to do about this case?" And I said, "Your Honor, it's the Supreme Court. We're going to follow it." uh, and then began uh, a series that, in fact, I argued a couple of cases about whether the SEC had a private right of action. I'm sorry, whether the central bank was limited to a private right of action and whether the SEC could prosecute aiders and abettors. And a lot of people drew a parallel between the Hochfelder case, in which the Supreme Court had held that scienter was necessary for 10b-5 cases, and the subsequent Aaron case, which held the SEC also had to find scienter to find a 10b-5 violation. And I thought there were significant bases to distinguish central bank from the Hochfelder Aaron situation, and that the SEC could continue to prosecute aiders and abettors. And I decided to write a business lawyer article in the form of a Supreme Court opinion on that question, simply because I decided if you could write an apparently credible Supreme Court opinion coming down that way, then the case hadn't been decided. Uh, and so I published that article in the Business Lawyer, and we had a couple of cases, uh, one of which I argued myself, but at the same time, and I'll show,
Which case was that?
uh, it's in the Ninth Circuit, and I'm not remembering the name of it offhand. Um, and the case, I do remember when I started to argue, the one of the judges on the panel looked at me and said, "Well, if the general counsel is here to argue the case, the SEC must think it's quite important." And I viewed that as a little bit of a victory all by itself. The case was remanded for reconsideration, but in the meantime, we'd gotten into the Private Securities Litigation Reform Act that I'm sure we're going to talk about. And we tucked a provision into the PSLRA uh, confirming the SEC's ability to bring aiding and abetting cases under 10b-5 so that the litigation question went away.
Okay. Backing up just a bit, your office had done an amicus on the central bank case, right? Before it was decided.
Yep, I think that's right. We had an active, and the General Counsel's OGC still does have an active amicus program. In fact, I would wish the SEC would do more to make available amicus briefs. If you go on, you can find them on the SEC website, but it's not easy, and it should be easy because they do reflect public statements of the SEC's position on things. And the SEC, to your question, uh, the SEC has always thought that private litigation was an important adjunct to the SEC's litigation, simply because there are so many thousands of uh, uh, participants in the securities markets who can be guilty of fraud, and the SEC can't uh, go after all of them. And private litigation has always been thought, and I continue to think, a valuable way of sending a message out to all of the other would be uh, bad guys to say, no, you can't do those things. And so uh, in central bank, we filed a brief in support of the petitioners, uh, saying that I think it was the petitioners, uh, saying that private litigation was important, and aiders and abettors are by and large gatekeepers, and it's important to make sure they're doing their job in the operation of the system.
Okay. Now you mentioned this is particularly interesting after the Supreme Court ruling. You still found or maintained that the SEC could go after lawyers and accountants in certain cases, aiders and abettors.
Yeah.
Is this does the SEC versus Zimmerman case come into this?
Uh, I don't think it came in that much. Maybe it did. I just don't remember very well, I'm afraid.
Okay. Okay. Anything else we should talk about on the gatekeepers subject?
It's a continuing uh, question, and uh, I'm not sure it'll ever be resolved simply because the line between uh, giving reasonable advice and participating in improper activities is so hard to define, and sometimes it's in the eye of the beholder, and the SEC enforcement staff is more likely to behold bad activity perhaps than the defense bar.
Um, Something that's very relevant these days is the issue of administrative proceedings. And you were in there in a very critical period for this, I guess. Is that right?
Yeah, it and it's changed a lot in the last 6 or 7 years. Uh, uh, some of which I've been somewhat responsible for on the other side. But yes, it's always been a troublesome question. When I came to the SEC, I had a daughter who was then in middle school, and I will not forget. I told her I was going back to be general counsel of the SEC, and I told her a little bit about what the SEC does. And she was taking a civics class, and she said, "Well, Daddy, is that executive, legislative, or judicial?" And I said, "Yes." Uh, and uh, the line between what's legislative and executive and what's judicial and the proprieties of, for example, the SEC uh, deciding to bring a case, prosecuting the case, and then having an in-house administrative law judge decide the case with appeal to the SEC always seems troublesome. Uh, and yet, it's a fairly efficient way of administering the securities laws or any other laws, take a different agency. And I think an awful lot started with the Roosevelt administration, and actually there have been some useful analyses. Adam Pritchard at the University of Michigan has looked closely into the evolution of the Supreme Court's view of administrative law, and has a quite good book out on that topic. And you know the in the 1930s, the general movement toward administrative law was embraced as an efficient way of bringing expertise to bear. And that system was in place and growing until perhaps, I'll say 2015, but I may be off by 5 years. But over a long period of time, the system was there and growing, and the environment grew around it. And securities professionals, to deal with the SEC as an agency, understood that and worked with it, and the courts accepted it. And then in 2015 or whatever it was, we started to rethink that. Ed Hamburger at Columbia wrote a book called Is Administrative Law Unlawful? That's had some significant effect, and a number of cases have challenged different parts of the process.
Let's talk
And
about your career a bit. You ran a task force on administrative proceedings,
yeah,
right? Do you remember that? What precipitated the creation of that task force?
probably my daughter's question. I was trying to, I would say, legitimize the process. We were trying to do more to insulate the administrative law judges from the criticism that they were a house organ. Uh, I think Judge Brenda Murray did a lot to establish the independence of administrative law judges, and I give her enormous credit for that. But I was trying to do everything we could within the structure as it was then accepted to avoid criticism that we were prosecutor, judge, and jury. And we established a separate division within the Office of General Counsel that worked with the administrative law judges and didn't talk to uh, the enforcement division, and had as much independence as we could within the confines of the Securities and Exchange Commission itself. We couldn't change the statutory procedure in which administrative law judge opinions are appealable to the SEC itself and then into the courts. But I could do a fair amount to establish the independence of the administrative law judges, and they were all in favor of working with that, and to have a call it a Chinese wall between the people in the Office of General Counsel who worked with the administrative law judges and the people in the Office of General Counsel who communicated with the enforcement division, and try to separate that and keep as intellectually honest a degree of separation as we could to establish the legitimacy of the process.
Any other measures come out of that besides the Chinese wall?
I think they were mostly aimed in that direction. Uh, I don't remember much more in the way of specific uh,
Okay.
provisions.
But that's a pretty important one. It has come up in the last
Yes,
few years when it's
yes,
been discussed.
it's come up, and the courts have been leaning toward saying we didn't do enough, or the statutory uh, setup was deficient. The Supreme Court in Jerkesi and in Axon, uh, sorry,
It's
uh,
okay.
has moved in that direction, and it's we'll see where it all ends. It's in some flux right now.
Who were the members of this task force? Was it all SEC or did you bring in people from the
It
outside?
was all internal.
Okay.
It's all internal.
Okay. Um, Anything else regarding the SEC adjudication program that the General Counsel's office sort of targeted or looked at in your period?
Uh, don't think so. We were also the judge's clerks, if you would. So we performed the services that the uh, uh, ALJ. We performed for the ALJ services that a judicial clerk would perform for a district court judge. Uh, and again, those people were insulated from the enforcement division. But if you look at it from 40,000 people at 40,000 feet, it was the SEC on both sides of it all.
Were there any ideas that came up that you would have liked to have done that you weren't able to do?
Uh, in limited to the ALJ environment, or
Yeah, but and I we can definitely talk about others too after that.
well, that they're similar but different, and uh, two quandaries that I had when I was there, and that I would have liked to have been able to do something about, and I've liked to have done something about it for the last many years since I left. One was uh, both ethical concerns. Uh, and one was that the process, at least then, and I think still, on enforcement action was it would work its way through investigation with the Division of Enforcement, and the Division of Enforcement would decide it wanted to bring a case, and the General Counsel's office would review it. Phil Parker, one of my deputies, had been a former chief counsel in enforcement and absolutely wonderful lawyer. Uh, we would look at it and we would either agree with the recommendation or disagree. And if we disagreed, then we would have a closed hearing before the commission in which the enforcement division would present their view, and uh, I would typically, sometimes I delegate it, would present our office view. Uh, and I remember a case in which I was subsequently talking with one of the commissioners who said to me, you know, you had that argument on such and such a case, and I thought you were probably right and we shouldn't bring the case. But the last two times you've had a disagreement with enforcement, we've come down on your side, and for the morale of the commission, I thought I really had to let enforcement win this one. And I understand that it is important for morale. You can't have enforcement always being shut down when they want to bring a case. But there's somebody who's a defendant or respondent in that case, and you're making her life miserable for the next X years. And how you resolve that tension is not a legal ethics question, but it's an ethical question as to how justice should be administered. And I couldn't see a way when I was there, and I haven't really seen anything since then. I do remember when Stan Sporkin was the director of the Division of Enforcement, he used to pound the table, and he had a reputation as being very difficult, but he used to pound the table with the responsibilities of the office not to bring cases unless they were right. The power of the government could overwhelm any respondent or almost any respondent, and you needed to discipline yourself. And that's one way to get to the right answer, but not all division directors felt as strongly about civil liberties as Stan Sporkin did, and tough question. Attention. The other ethical question, and it gets into the ALJ process some. Uh, a lot of SEC law, so-called, is made by settlements. In fact, there was an SEC proceeding not too long ago. I was not involved in it, in which there's a footnote in which the SEC criticizes the respondent in that case, saying, we've had a series of cases and the respondent should have known it was wrong, and all of the cases they listed were settlements. They weren't cases the SEC had won, they were settlements. And so you have to recognize that as a practical matter, settlements make law. You have a series of settlements over 5 years, and all of a sudden they've crept into the notion of law, and the Division of Enforcement certainly regards them as very close to being law, even though it's all settlements. So what's the right answer if you've got a principle that the SEC wants to establish that's sort of on the fringe, uh, and you've got two possible respondents, one of whom is rich and perfectly able to defend herself and willing to go to the mat with the SEC, and one of whom is poor and will accept any settlement. The practical answer might well be you drop the case against the rich person because you might lose it in court, and you bring the case against the poor person, but none of us likes that answer. But should you bring a case that is going to be fought that you might lose? Should you and don't forget, by hypothesis, you believe you've got the right answer here. Uh, what's the right way for the General Counsel to advise the commission on that kind of case? What's the right thing for the commission to do? And I've tried to. There are some principles of uh, ethical constraints affecting prosecutors in the criminal context, but I've not been able to persuade, and I didn't have the time myself to sort of think that through and figure out what a comfortable answer is.
But you did find yourself in that position when you were general
Yeah,
counsel?
yeah, I did.
You mentioned the PSLRA. Um, to talk about sort of the building, uh, the building move towards deregulating somewhat, the sense that litigation was going too far, frivolous lawsuits, all of that.
Yeah, yeah. That was a concern. I can't. I can pinpoint one critical point, but I don't know how much before that. It would have been in January of 1994. Chairman Levitt was delivering a speech at the San Diego Securities Regulation Conference, which is a widely attended conference of, I think back then it was around 1,000 people showing up in San Diego to hear 3 days of discussion about the securities law. And pretty sure Chairman Levitt and I had talked about the frivolous litigation problem and trying to rebalance the equation a little bit so that we didn't uh, eliminate meritorious actions, but we did eliminate the drag on business and commerce, the frivolous litigation, because if you've got a class action uh, that has potential damages in the billions of dollars, it's going to cost an awful lot to fight it, and it may be nothing other than what they call a stock drop case. Something out of the ordinary happened, and you know, in the current context, Elon Musk became a part of Doge, and Tesla's stock drops. And should Tesla have done more to disclose that kind of issue? And a lot of those cases weren't legitimate cases and weren't really addressing securities law concerns. And so he gave a speech at that San Diego conference teeing up the issue. And there had been a couple of law review articles. I remember one particularly by Elliot Weiss, uh, who in the Yale Law Journal, and he is now on the faculty, I think, still at the University of Arizona Law School. And I'm pretty sure it was Elliot's article that initiated the idea of a representative plaintiff, so that it's not just the lawyers, but it's an actual plaintiff who was damaged making the decisions. That was one of the ideas in the PSLRA, in what became the PSLRA, and that probably consumed a fair amount of energy, as you'd expect. Opinions were divided within the commission staff, and Arthur Arthur Levitt could go one way and then the other. Listen to one set of arguments and say, "Yeah, we should stop that," and then listen to the other and say, "Well, maybe we shouldn't stop that." Uh, it's a difficult thing to find the right balance, preserving the right of plaintiffs to bring a case, uh, but making it harder to bring the frivolous case. And we had congressional testimony. I had late night drafting sessions with the Senate Banking Committee. Their chief counsel at the time was Bob Jufra, who is now a managing partner at Sullivan and Cromwell. Uh, uh, it was controversial and difficult, and the chairman came down on the side of doing something, supporting the legislation. Uh, President Clinton vetoed it, and his veto was overridden, one of the few veto overrides. Uh, but it came into law, and I think it's had some success over the years in um, being making it possible to uh, dismiss uh, the frivolous cases at an earlier stage without interfering with the meritorious cases.
The decision to submit an amicus in Frank versus Cooper, was that part of this effort?
Yep, yep, it was all part and parcel of our drive, and you know, I was on the side of doing something uh, such as the PSLRA, and uh, although amicus briefs go through the full commission, uh, the brief, what I recall of it, was supportive in that regard.
Remind me how that worked out. Did the court side with the
It's funny,
SEC?
as you were asking, I was trying to remember, and I just I
Well,
was
we can
drawing a
both look it
blank.
up.
It's
We
been a
can both
long
look it
time.
up. Um, oh, you created a litigation analysis unit, another prong in
Yep.
this effort, I guess.
And
How did that work?
and um I'd say not all that well. We tried to look at litigation and weigh in, uh, and we filed a few briefs at the district court level, which was unusual, uh, in private actions. Uh, but I don't think the effort continues, and it didn't really do very much. It was taking more time than it was worth,
Okay.
frankly.
Okay. Now, one of Chairman Levitt's signature efforts was pay to play, and you ended up getting involved in MSRB Rule G-37.
Yep, yep. And that, well, in fact, when I came to the commission, I'd never argued a case anywhere. As I said, I was a sit-down lawyer, not a stand-up lawyer. Uh, but when pay to play came up, MSRB Rule G-37, which essentially said if you're contributing to an election of somebody who can control the allocation of securities business, you can't contribute and do the securities business. We wanted to get away from the soft bribery, if you will, that was involved in that process. And uh, when I looked around the office of the General Counsel, we had solicitor at the time was Paul Gonson. Paul Gonson was a superb lawyer who had a remarkable knack for explaining complicated securities law issues to a court in a way that didn't talk down to the court, but simplified the process. And I don't know how Paul did it, but he was wonderful. And under Paul at the time, Jacob Stillman. And Jake, when he got a case, he dug down and knew everything about that area of the law. But if you had a case about 10b-5, he knew everything about 10b-5. If you asked him about 10b-6, he'd say, "What's that?" Because he hadn't had a case on that. And so uh, uh, I mean, he probably knew 10b-6, in fact, but you understand the point. But I looked around the office and we were challenged on municipal securities rulemaking board rule on pay to play, challenged on uh, constitutional grounds. And I was arrogant enough to think I was as able to argue a constitutional case as anybody else around. And so I decided I would argue that case myself in front of the DC Court of Appeals. And I took a different case. I mean, when you argue a case in the DC Court of Appeals, the entire office of the General Counsel comes down to watch. And as I said, I'd never argued a case before, although I was interested in doing it, new experience. So I argued an earlier case in the Fifth Circuit just so I could have a experience, a rehearsal out of the office where I wouldn't have everybody coming down to watch. But the case was challenged in Blount against SEC, and Harvey Pitt, subsequently a chairman, argued the case for the Municipal Securities Rulemaking Board, and I argued it for the SEC. I distinctly remember one argument that I didn't make, uh, which was that the court should use what was then known as Chevron deference, since eliminated by the Lower Bright case. The court should defer to us because the SEC was in the business of regulating speech. But I thought that might not appeal to the court. So I went into the argument saying that I was going to use the word bribery as often as I could. Uh, and I got one question from the court. Remember, I don't remember which panel member it was. One question from the court saying, "How is this different from deciding to go out and play golf with somebody from the group that awards business?" For a minute, I thought about saying, "Well, now you're talking about something serious," but I decided that wouldn't appeal either. Uh, so I said that was potentially trivial and not worth the effort, but actual cash contributions amounted to bribery. That's bribery, Your Honor. Uh, and of course we won the case on the constitutional grounds, and it gets cited quite regularly.
Is that the Supreme Court case you're referring to?
That was D.C. Circuit.
DC Circuit, yeah, the
I,
Blount
I,
case.
I never argued a case in the Supreme Court.
Okay.
Used to be true that general counsels were given that opportunity, and I had the opportunity in Gustafson, uh, which was a Supreme Court case, but I thought we were probably on the wrong side of it, so I shouldn't argue it. And we lost in the Supreme Court, but uh, I, it wasn't a very good opinion, I think, by Justice Kennedy. It wasn't a very good opinion in terms of coming to grips with the issues in front of the court, but the SEC lost in any event.
You mentioned Paul Gonson, Jake Stillman. I think you mentioned Phil Parker back there. Talk about some of the other people that you relied on, and maybe some of the folks that gave continuity to the Office of the General Counsel.
Those three were the key people. Eric Summergrad, of course, was there and an important person. Rich Levine was important in the office. It was a good group. It still is. The Office of the General Counsel, I think, has drawn the best and the brightest people. I don't mean to insult the other divisions, but I thought the Office of General Counsel was the cream of the crop. I thought we really had a good, solid group. Uh, well, uh, bright people, hardworking people. It wasn't unusual to see people staying there till 10 or 11 at night working on a brief. Dedicated people. I thought the country was lucky to have people like that working for them.
Did the office grow considerably under your leadership?
Not very much. It stayed about the same size, probably about 150, something like
Okay.
that, during my time.
Okay. You'd mentioned an attempted reorganization. Tell me about what drove that. What were the circumstances? How did that work out?
My naivete, and it worked out terribly. Uh, I thought one of the things that sometimes comes up and came up at the SEC was a multiplicity of titles, so that you had deputy general counsels, associate general counsels, uh, uh, assistant general counsels, deputy assistant, deputy associate, deputy assistant associate. I mean, you can make up a title to go as far as you want, and I think if you sketched out what we had something like 8 or 10 layers of hierarchy, and coming from a law firm that had a very flat organizational pattern, I thought we should simplify, eliminate, uh, and be more like Department of Justice, which doesn't have very many layers of hierarchy, and uh, hierarchy begets bureaucracy and begets more reporting forms, et cetera. And I thought that was a more efficient way to work, and that we should try to get into that position. And so I put out a memo that said we're going to eliminate all these titles. And unfortunately, it created quite an uproar. It turned out that in the government, where circumstances are such that people are being paid a lot less than they could get in private practice, uh, they attached a fair amount of emotional importance to titles. And I had a storm of protest. And after weathering the storm for about 2 or 3 weeks, I said, okay, I give up. We're not doing that after all. It was a tough thing to do, and I couldn't get there.
Yeah.
Uh,
Would the union have been involved in this too?
that was before we had a union at the SEC.
Okay.
I'm,
Okay.
I'm, I'm sure the union would have been if it had existed then. Yep.
So you were there, what, 2, 3 years?
Yeah. Yeah. I came
Okay.
in, October, came in 2020. Sorry, came in 1992 and left in, 1995.
Any other highlights, things that you did, decisions you made that were important in that time that we haven't discussed?
Um, I'm sure there were none come specifically to mind uh, at the moment, and I spent some time thinking about it ahead of before we started this. I think you've covered pretty much all the
Okay.
important groundwork.
What about the decision to move on?
Uh, it was time. Uh, I'd been there for 2.5 years, 3 years, and uh, turns out that that's longer than the average general counsel, but with a couple of exceptions. Dan Gilsher. Uh, Dan was there for 10 years or something. Uh, but uh, yeah, it was time. I once heard the general counsel of another agency, which will both he and the agency will stay unnamed, who gave a retirement. They had a retirement luncheon for him, as people do, and at his luncheon, which was mostly people in his agency, he said, "You can tell when it's time to retire from these positions because your bank account will tell you." And I thought that was kind of insulting to the other people in the agency who were long time and going on and getting paid a lot less than they could have in the private sector, and resolved never to say anything like that. But there comes a time when you think you've done what you can, and I talked to the chairman about it, and we decided it was time.
Okay. What was the next step?
Next step was going to back to Solomon Brothers. I mentioned earlier I had been the acting general counsel of Solomon Brothers, uh, and the general counsel I had brought in, actually an old friend of mine, Bob Mundheim, former dean of the University of Pennsylvania Law School. Bob had been uh, general counsel, was general counsel then of Solomon Brothers, and he suggested that I come in to run the internal audit department because he said, running internal audit, you're going to see the entirety of Solomon Brothers, which was then a major investment bank on a par with Goldman Sachs, and uh, without making any promises, you'd be in a position to come into my position, he said, as general counsel. And I didn't know much about internal audit, but I learned a lot and had a wonderful experience. So that subsequently, when I was chief legal officer at Millennium Management, uh, I instituted an internal audit function then because internal audit is an extraordinarily useful and underappreciated role. And I never would have thought of that, particularly if I hadn't been running internal audit at Solomon Brothers. So I had that experience. And meanwhile, Solomon uh, merged first into Travelers with Sandy Weil. I'll go back to CBWL, Kogan, Berlin, Weil, and Levitt. That Sandy Weil Citigroup was the Weil, and Arthur Levitt was the Levitt. Uh, we moved into Travelers, and then Travelers had merged into with Citibank to form today's Citigroup, and Travelers Insurance subsequently spun out of that. But that wasn't my kind of organization, and I went back to the law firm for what turned out to be 5 years to the day before I went to Millennium Management as chief legal officer.
Millennium is a hedge fund, is that correct?
It is. It's a hedge fund based in New York with today $75 billion under management, one of the largest hedge funds. And
What were
and
some of the new challenges that came your way at Millennium?
uh, organizing a department, organizing compliance. When I came there, our total legal and compliance group, we were smaller then, but the total legal compliance group was, I think, 7 or 8 people. And when I left, the legal compliance group was about 150. And it was uh, compliance, internal audit, and legal. And compliance was a critical part of that. And now I'm teaching a course in compliance because most of the people doing compliance are lawyers, but not very many law schools tell you anything about how to handle a compliance function and enjoying it immensely.
Terrific. Anything else about Millennium or your career that we should touch on?
Boy, I think we've covered a lot in the time allotted, and I appreciate your questioning it. I wasn't sure what to expect, but I think you've really done a good job. Thank you.
Oh, thanks. Well, you had lots to say. I really appreciate your filling me in on the Office of the General Counsel, from a participant's perspective, but also from a legal scholar's perspective. It was a lot of fun.
Office of the General Counsel is a lot of fun. Probably the best
Well,
job I've ever had.
terrific. Thank you.
Thank you very much.